name is Maysam. I'm an associate over at Wilson Sonsini. Technically my office is in Del Mar, but I'm up here in Orange County. I live up here in Orange County, and I'm around ULP. Pre-COVID, I was around ULP all the time, and now I'm virtually around ULP all the time. So, just to begin, Wilson Sonsini, we're a global law firm. We specialize in corporate and intellectual property law, but what separates us from the other kind of big law firms is that we really like to work with emerging tech, life science, venture-backed companies. We specifically like to really, work with innovative companies that are truly changing the world. So that's where kind of our expertise really lies. And while we have mostly corporate attorneys, we have, over 165, closer to 200 patent practitioners, including myself, agents, scientific advisors that have a wide variety of expertise. So we work very closely with these innovative companies to make sure all their IP is secure. So I don't want to spend too much time on the firm, but as Emily mentioned, these slides will be available, and you guys can refer back to the slides or reach out to me to learn more about the firm. But today's topic is patents. As some of you may know, there are multiple forms of intellectual property, but for tech and life science companies, especially these innovative companies that I was mentioning previously, patents are without a doubt the most important form of IP. As you see on the slide, for example, you can register a trademark for your name. You can, copyright some of your like artwork or some of your like manuals or things of that nature, or maybe even keep some of your processes a trade secret. But the value of a tech company is going to be in its patents, because a patent on your method, service, product, what have you, that's the form of IP that's going to keep people from copying your invention. So high level, what is a patent? It's a government granted right. And the most important thing that I want everyone to take away from this slide is that it's the exclusive right to exclude others. It doesn't necessarily give you the right to do whatever your patent's on. We can talk about that. I've actually talked about that before, the difference between patentability and freedom to operate. But the important thing to note is that this piece of paper will give you the right to exclude others from practicing any of your claims in the patent. So the claims are going to be, a patent application. I don't know if you've ever seen one. It can range from 20 to 200 pages. But the real part that gives you the right to exclude people are those numbered claims at the very end. So today, what I want to really talk about is, what do you put in those other 50 or so pages, and what do you need? What do those 50 or so pages need to say so that you get really powerful claims, so that you can exclude more and more people? Last note on this slide I want everyone to understand is a patent is good for, not counting some certain adjustments that we can get into later, 20 years from the earliest filing. So we should keep that in mind as we talk later today about timing your filings. So from a business perspective, why does this exclusion thing that I talked about, why is it so important? Well, you don't want it, first and foremost, you don't want to get ripped off. As I said earlier, people can, without a patent, maybe you have a trademark, people can just rebrand your process and get around your trademark. But you can't do that with a patent. Having that patent is going to be, like I said, it's going to exclude everyone from being able to practice whatever it says in those claims. The other aspect of patents is you need to know what your competition is excluding you from doing, so that you don't get sued. Patent infringement is it's one of the more costly types of lawsuits. So we definitely want to avoid that. And as an offshoot to that, when you're engaging in different sort of collaborations or agreements with third parties, you might want to know what else is out there before really divesting your resources into that engagement. So everything I just talked about goes into these, two goals that, is really the two major goals for almost all emerging companies: securing financing, getting paid, and enabling an exit strategy, whether that's, selling your pieces, or getting bought by another company, or, going IPO, what have you. So to understand what you need to file that patent, we have to really look at what are the requirements for patentability. What are the requirements for those claims that we were just talking about? There's the first requirement, disclosure. Those 50 or so pages before the claims need to describe to the world how to practice those claims, how to make those claims. Those claims need to be novel, and they need to be non-obvious. So these last two are with respect to what have people done before you. We'll be touching on these two kind of prior art type rejections, the other people's work, towards the end of this. But the main topic for today, with respect to these prior art pieces, is how do you prevent yourself from being your own worst enemy? And a complete topic for another day, which would be the fourth kind of requirement for patentability, is subject matter eligibility. But we can spend a whole nother seminar talking about subject matter eligibility. But as things have been kind of playing out in the courts more recently, there's a lot of wiggle room with things you can patent. You could actually patent almost anything, as long as these other three requirements are also met. As I noted, special care, especially in the past, more so for diagnostics, natural products, and software. But even in today's courts, we're actually seeing even more these kind of patents get issued, which is great. We want more patents. It drives innovation. So, what is disclosure? That was the first requirement we mentioned on the previous slide. So there are several laws that really govern what are the disclosure requirements. But the main point, the main thrust of these laws can really be summarized as your patent application, those 50 pages before the claims, needs to describe your invention or those claims with enough detail so that someone of skill in the art can practice the invention, make, use, whatever those claims say. Now, that doesn't mean it has to teach, someone off the street how to do these claims. There's a bit of, you can expect that the person that's reading your patent is someone with skill in the art. That word in itself, though, one of skill in the art, that's another legal term that can take, hours to debate. But for what I want everyone to take away is just that when we talk about this level of disclosure, we're not talking about just someone off the streets. We are talking about someone who's more or less informed in the industry. So to break down that statement, it can, as I mentioned, it can mean a lot of different things, but the best kind of commonality between all these different types of inventions for what you need for disclosure is describing the structure and function of what you're inventing. Those are the two critical things, more so the structure even, but being able to describe that structure and function in your patent application, that's the key to really meeting this disclosure requirement. And as we'll talk about later, this is where kind of the skill of the patent attorney comes in here, where you want to draft your patent application in a way so that you're not limited in your structure. I'm about to show you guys different ways to show structure, but we have to think about, we don't want to limit ourselves to just one structure or even two different types of structure. Before we get into this, did anyone have any questions thus far based on anything that we've already discussed? I'm not seeing anything on the chat. Okay, so as I mentioned, different types of inventions have, structure can mean different things for different types of inventions. For instance, devices, you should try to include the possible dimensions for your device, the different the different components of your device. Or this, maybe your invention is a new kind of arrangement of different components. But as I mentioned earlier, when you're putting that patent application together, you got to be careful as so that you're not limited to just this picture or just this picture. You want to be able to, technically a provisional patent application, you could just submit a whole bunch of pictures and say, this is, these are the different kind of embodiments of my invention. But that would be harmful, because you want to support those pictures with words that kind of say things like, some embodiments, my invention has these 3 stacks, or in some embodiments, my invention has this handle, or this cutting edge, a lower cutting edge, and sometimes it has an upper cutting edge. Sometimes it has both. You need to kind of say those words so you're not limited to just the pictures. But these pictures are at the same time critical to describing what exactly your claims are going to be. Then in the land of therapeutics, what are the different ways you can describe structure? Well, you can put in the actual molecular kind of compound that you're trying to patent, the amino acid sequence of maybe your antibody or your virus, or your nucleic acid sequence, I should say, when we're talking about antibodies and viruses. Or let's say if your invention is, a particular formulation or some sort of, special pill, let's say, you need to describe, what is the exact, what are the possible formulations. So again, these are different ways to show the structure of your claims, of your invention. Now, how do you show function? Function, the key to showing function is going to be the data. Now, as I'll get into later, not all data, you don't need to show like human data or even animal data. That all depends on kind of the prior art, as we'll discuss in a few slides. But what is data? It's showing that your thing actually works. This was an invention for a cancer therapy. They showed the tumor volume control versus their product, or just showing, okay, if you use our product, we're seeing this much more expression of a certain biomarker, or trying to see using these different. See, here's actually a good example of taking from a patent application where they're showing multiple structures. So, and then the way that patent application was written, they're not limited to just one structure, and they have the data for all of these, and that could give them the opportunity to get a claim that captures all of the structures. So that goes back to what I was saying earlier about the art of the patent practitioner is to craft your application a way so that you're not limited to just one. So how much disclosure do we need? How much data do we need? Again, that depends on the prior art. The more prior art there is, the more crowded your space is, then the more disclosure you're going to need to, show why your invention has not been done by other people, or why your invention is better than the prior art. So some practical examples of that chart we were just looking at. Let's say your invention is a device or system that's made up of a completely unprecedented arrangement of components or a completely unprecedented composition. Then in those situations, you might actually not need any data. You just need to disclose that special arrangement or that special kind of, composition of your device or system. And if no one else has even come close to doing that, then you don't need to go into all this data showing how great it is, because no one's ever done it. Conversely, if you're, let's say, the first to synthesize a whole class of molecules that no one has ever heard of before, and you're the first person to do it, and you think, okay, this thing could be good for, let's say, treating cancer, you don't need to start putting it into mice, let's say, to show that, that I showed a graph earlier that had the tumor volume. You might not even need to go there. You most likely don't even need to go there. In this case, you can just show that in a Petri dish, oh, okay, my compound is hitting that target. And if you're the first person to kind of show that this compound hits that target, you would most likely be awarded a claim that is, this compound or class of compounds for treating cancer. But on the very narrow end, let's say you synthesize not a completely new compound, but a new single compound amongst a class of compounds that's already known to treat certain cancers. Or, everyone knows that PD-1 antibodies, for instance, treat some certain cancers. But let's say you design a certain PD-1 antibody that works even better than everyone else's. That space is going to be crowded, as we talked about, because everyone has, everyone knows that these PD-1 antibodies can treat cancer. But so in this case, you would need, to actually show in an actual cancer model, whether it's humans or animals, showing, okay, that my compound compared to all the other similar compounds actually works better. So this is kind of the a little range of when you can get away with not so much disclosure, or you might need a lot of disclosure. It all depends on the prior art. So why do I keep kind of conflating disclosure with data? Because if we're thinking about, okay, what's the point of a patent? It's to exclude other people. We want to try to, especially if you're investing all this money in the patent, you want to try to exclude as many people as possible. How do you maximize the amount of people you want to exclude? You need you need broad claims. That's what you can kind of, when you say a strong patent, that's more or less saying, does your patent have very broad claims? If you, let's go back a couple slides. If your patent is limited to just this structure or this long sequence, then someone can come around and maybe just change one little component, and suddenly you can't sue that person anymore, you can't exclude that person anymore. So we want, you ideally want to get a patent that covers that whole class, a whole class of compounds. Or if we're talking about a device, we don't want your claims to require that handlebar. What if someone makes the same device without the handlebar? So that's why with the strong patent attorneys will always craft the claims to only require the really essence of what you need to be better than everyone else, and all the kind of extra stuff is omitted from the claims. But by doing that, by writing those broad claims, you're inevitably going to open yourself up to more prior work. Going back to that kind of chemical compound I was showing earlier, maybe no one has shown that no one has ever synthesized that one compound. So there's, there might be no prior art. But if your claim is written to, broader than just that one compound and a whole bunch of similar compounds, maybe other people have made those similar compounds. So how do you get around that prior art? It's going to be your data showing that your compounds are going to be are better than the prior art. So final notes on disclosure, and this last part is this is something that's kind of sounds a little bit odd, but it's completely true, is that your disclosure, your data, can actually be prophetic. And what that means is you don't actually have to have done the experiments for prior to filing your patent. As a reminder that those laws, the legal standard, is that you just need enough description so that your invention, more or less makes sense to the reader who already has skill in that field. Doesn't necessarily mean that what you're describing or your experiments have to have been reduced to practice. So that's a strange kind of statement, but it's very important. Now, if you're kind of in that space that's very crowded, and you don't have any actual data to show that yours is, what you're inventing is better than better than the prior art, better than other people's previous work, then, it's going to be very, very difficult or impossible to getting an issued patent based solely on this prophetic type data. But if the space isn't so crowded, I've drafted many patent applications where the data is actually, it's something that we're working on, or, something that this is how it should work. Again, those are going to be all instances where the space isn't really crowded. And so that being said, the best way to really leverage the use of prophetic data is thinking about what experiments you're going to perform, and how, if in the ideal situation, how should that data look? So by doing that, then perhaps if you have enough time, you can actually you can supplement your filing with the actual working data. We'll talk about in a little bit where times where you can supplement your filing. But it's very important to really think about, you can't just, if you just start really, throwing in prophetic data that goes all over the place, then that goes back to this legal standard. How does it, someone with skill in the art, if you have just a bunch of prophetic data, how is that going to make sense with, to that person with skill in the art? I'll stop here for any questions. I feel like this is we're starting to get into the weeds a little bit. Okay. So we'll come back to we'll come back to how disclosure fits in with the overall question of when you file a patent, in view of some of the other things I'm going to talk about. But the biggest takeaway from disclosure in terms of filing a patent would be, you should time your first filing such that you can get the actual working data within 1 year of that first filing. And we'll go back to why that is, but that's kind of the idea that I want everyone to kind of keep in the back of their minds. So with disclosure aside, I mentioned that the other big requirement for patentability is novelty and obviousness. So those, as I mentioned, go into this concept called prior art, other people's work. So as I mentioned earlier, you can spend a whole, not even just an hour talking about it, maybe a whole years of law school classes talking about how, what's the difference between obviousness and anticipation, or novelty, I should say, and how to get around these different things. But for today's talk, especially with the theme of, when do I file my patent, I want the takeaway to be how to not become your own worst enemy. How do you make sure that you don't create prior art for your own patent? One of the biggest instances, the most common instance I've seen for this novelty destroying art, or a piece of prior art that just completely covers every aspect of your own invention, is the inventor's own work. So, even when a U.S. patent examiner is going to is looking at your patent, one of the first things they do is just take the inventor's names and just do a Google Scholar or a PubMed search of the inventor. What have they done? Typically, a researcher is going to work in one field throughout their career. So when you're looking at one of their patents, a patent that they invented, chances are some of these Nature articles they've published in the past are very close to what they're patenting now. So it's very important to, this concept of not becoming your own worst enemy is very, very important. And unfortunately, it could be, it's a fatal mistake that happens. So right up top, the takeaway is file a patent application. Even if it's just a provisional, usually it will be a provisional, before any sort of disclosure of your invention, even a confidential disclosure. So this means, whether you're talking about it at a seminar like this, if you're going to go to like some sort of symposium, if you're talking to investors, if you're working at a university and you want to submit a manuscript, make sure you go talk to your tech transfer office before really telling anyone else about how you should how the university should go around patenting this your ideas. So there are some, if depending on how savvy you are, there are exceptions baked into U.S. law where you can actually disclaim any of your own prior disclosures as long as you're one of the named inventors of a patent application. That window is only a year long. So for instance, if you give a talk on February and you go and you finally get around to talking to your tech transfer office or your patent attorney, in June, and you file your patent application, you would be able to disclaim that February talk or the slides that you presented then. However, thinking globally, very few foreign countries provide these same exceptions. So you might still be able to pursue, patent protection in the U.S., but there's a good, Europe, China, their standards for this type of situation is a lot more strict than the United States. So that's one great thing or very important thing to consider. Then if you're working with, if you're collaborating with the university or even another private company, or even collaborating with just an individual, you have to make sure that, you have to think about, okay, are they publishing anything that might, jeopardize my right, our ability to get a patent application. So a lot of times when I'm working with companies that are engaging in joint ventures or licensing deals with another company or institution, you have a provision where you say, okay, if I respect the fact that you want to publish your findings. We gotta kind of create some hype, create some noise for what we're working on. But you need to submit to us the draft of what you're going to publish 60 days, 30 days, 90 days in advance of submitting that publication. The only reason that clause is there is so that you can take that draft publication, take it to your patent attorney or your patent agent and say, okay, this is what our collaborator is going to publish. Do our patents cover everything? Do we need to file a new patent before this thing goes out? That's kind of the prudent way of going about those kind of relationships. I'll get into this bullet point a little out of order. The last thing I want to mention about, kind of more in line with prior art is selling units. Even a confidential sale, in most cases, even a confidential sale can fatally anticipate your patent. Anticipate's kind of a loaded term, but can fatally, destroy the novelty for your subsequent patent filing. So there is case law that says, okay, beta testing, it's a gray area, but if that fight can be avoided by just if you have the means to file that patent application before the beta testing, you should go ahead and file that patent application. Lastly, I mentioned that even a confidential disclosure can be problematic for you. So a confidential disclosure isn't problematic in terms of prior art, but it's still problematic in many ways because a lot of people don't know this, but it's not that difficult to get around a confidential disclosure. Like let's take a hypothetical here where you are a company that's let's just say making drugs for cancer, and you have this new cancer drug that works very well, and you're thinking, okay, maybe a Pfizer or Johnson & Johnson might pay me a couple $1 million for this, or even a couple $1 billion. Well, some made up number. So you say, okay, you got a meeting with these guys, so let's go kind of confidentially present our ideas, and if they like it, they'll give us the $1 billion. So you have them sign NDAs, which chances are they won't, but let's say they do. They sign your NDAs, and then you have a good meeting. don't hear a call back, and a year down the line, you see that they're starting to research that same compound. And you're, what gives? I thought we had a confidential disclosure. And they come back at you along the lines of with something like, oh, well, actually, you might have not known this, but we were also researching that same compound, and you just really confirmed what we already figured out. And what you told us isn't actually anything surprisingly new to us. And maybe they didn't have your exact compound, but let's say they were, if they were very close, that's going to be a whole legal battle. And on the surface, they're going to be in the, not the right, but they'll be free to work until you sue them. And then that type of lawsuit is going to be a very costly lawsuit. How do you avoid that whole mess? Filing that patent application before you even have that confidential disclosure. So all this being said, to everyone at my firm, your tech transfer office, and anyone that's part of this process, everyone understands that publicizing your ideas, your inventions, it's a key aspect to building your business. You gotta get the word out. You need to talk to investors. You gotta generate money, generate hype, anything like that. So we all understand that, and different situations can be dealt with differently and in a very as cost effectively as possible. But the key here is to just communicate with your patent practitioner. If you're a professor, communicate with your tech transfer office. Keep that dialogue moving, and just be transparent, because if you're not transparent and one of these things happens, then more or less everyone can be screwed. So very important to just keep that communication open. Now, what I want to get into, these last couple slides, it'll really look into not just filing your first patent application, but also how do you time your several filings to kind of create a really nice patent portfolio. Some people might be familiar with Humira, and there's something out there, I don't know the exact number, but there's over 100 patents that cover Humira. And you might ask yourself, like, how is that possible? One aspect of that huge portfolio is implementing the strategy that I'll be talking about soon. But for every patent application, the earlier your priority date equals less prior art. So I was talking about that, I brought this up with those prior art rejections when we're talking about novelty and obviousness. But you want to balance the timing so that you want to get ahead of prior art. You want to make sure that there is, whether it's your own prior art or other people's or third parties. But as we talked about earlier, you still need to be at a spot where your disclosure is there, or your disclosure will be there within the 1-year conversion date of your provisional patent application. And when I say provisional patent application, that's going to be the most efficient way of securing that early priority date. A provisional patent filing, that's all it really does. It secures a priority date for everything that's in that provisional filing. So if you just submit, some people have come talk to me and saying, oh, I can just, submit a bunch of pictures or my PowerPoint slides that I'm about to give. And as a provisional patent application, why do you need to, spend $5K, $10K and like write all these words and just for a provisional? Well, if you just submit those pictures that I showed you earlier, then you really have only secured that early priority date for just those pictures. Okay, so that's where you got to balance priority date, disclosure, and ultimately cost. Any questions? Any questions on so far about priority dates, securing that priority date, what should be in your provisional, differences?
Okay. I have a question.
Yeah. Hey, how you doing?
Hi, thanks. I came in a little bit late, but I heard this part, and I guess so. If I already had papers submitted, a manuscript, would that be the, I guess, priority date, or would it be the publication date?
For a manuscript, it would be the publication date. So that's not the day it gets printed, but the day that it's available online. Interesting. Yeah, there's some case law on grants, which make grants a kind of a gray area, where it's the big date is the day that the grant gets funded. Because once it gets funded, then there's a question as to, okay, it might be subject for public information disclosure, and does that mean it's publicly available? So with grants, I would try to file it before you submit the grant, or in your case, before you submit the manuscript, but at least for grants before it gets funded, and for manuscripts, at least before you submit it, or before it gets published. You really should be you should be trying to, if you're working if you're at a university, talk to your tech transfer office to make sure that the ideas get captured in a manuscript draft. And in a lot of ways, I work off manuscript drafts all the time, and in emergency situations, you can just submit that manuscript draft as your provisional patent application. But then going back to what we were talking about earlier, you still want, in the ideal situation, you're giving it to, a patent practitioner so that they're expanding it out. So you're not limited to just what's in the manuscript or just the set of compounds that are in the manuscript. Great question, though. So if there are no other questions, now we're talking about leveraging your own patent filings, stacking them in a way to really maximize your patent portfolio. So let's think about that Humira situation. How can you use different patents to kind of extend, go beyond that standard 20-year term from your earliest patent? Key date here is the publication date. So as we were talking about prior art earlier, I said that was previous work that's been published. For something to be prior art, in most cases, it needs to have been published. Not all cases, and that's another part of the year's worth of law school classes. But in most cases, it needs to be published. So when do patent applications publish? It's 18 months from the earliest priority date. What does earliest priority date mean? This provisional filing. Why is the term earliest there? Because as I've been mentioning throughout, you can supplement your provisional filings. You can add to your patent application over the course of that initial first year. But if you're claiming priority to that very first one so that there's less prior art, you can expect your publication date to be 18 months from that first filing date. So that's a big date. In my line of work, for every patent we file, we have a million red flag calendar reminders for this 18-month publication date, because it's before that date that we really need to work with the company, work with the inventors, and say, okay, what are your improvements? What's the next generation? Where are you going now? Because we need to file that provisional application, or any patent application, but usually a provisional, to get a priority date just prior to the publication of your previous work. Because what we don't want is your previous work we don't want you to be your own worst enemy, going back to this. And if you think about, okay, the next generation is just going to be, a couple little tweaks to what you previously patented, then we definitely don't want your previous patent application to be prior art, because that's going to be very hard to get around. So this is a visual to kind of, really map out what I just talked about. Year one, you file your first US application. Let's say there were a couple supplements in the middle. Then you convert it into a non-provisional. And then right there, 18 months, you're going to file the second family, your second line of provisional to non-provisional. So and then this chain just kind of keeps going and keeps going. And a little bit off topic, but I'd be remiss not to mention it. This step 4, the choosing the foreign countries. This is typically the most expensive part of starting your patent portfolio. Luckily, it doesn't happen until 30 months from your first provisional filing, but it's always something to really consider. This date right here, 30 months from your provisional filing, it can be anywhere from, you know, 5K if you're only going US to 100K if you're going into, it could run up to 100K just by going into maybe 15 countries. It's a lot of translation costs. Those will really rack up. So another kind of visual and even a more kind of narrowed example of how to really leverage this, you know, choosing your different filing dates is, let's say that first family is, you know, your key, you find out that, okay, this new compound hits this particular target, and that target is known to cause, you know, a certain class of cancers. So your first filing, your first patent family, your first patent is going to go over that compound, and maybe that compound for treating your cancer, if it's in fact, you know, if it's in fact like first case or first in class. In that case, like I said earlier, you wouldn't really necessarily need to start putting it into animals or anything. You can just go off your Petri dish data. Then over the course of your research, you know, or I guess going back, the plan would be you get this patent on file and you start going to investors saying, hey, I discovered this compound, it's patent pending, or maybe you already have an issued patent, and you're gaining funds, you're raising funds. You take that money and you start optimizing your product. In the world of small molecule drugs, let's say you figure out that a certain enantiomer of your first compound, or you know, maybe you change one little functional group, and suddenly your results get way better. Then that in itself would be a new patent family. And then finally, you know, you go around, you know, you show that patent along to more investors, and you say, I got this thing bulletproofed. I have, you know, my first patent family. It's got this whole class, and then I discovered my MVP that is even better than everyone else, or all my previous work, but it's still covered by this one. So now, you know, we got 25 years of patent protection on it, and you get enough money to finally go into the clinic. In the clinic, you figure out, oh, okay, I need, you know, 500 milligrams a day of this particular drug. That'll give, you know, that's the limit before it starts, you know, killing people or getting people sick. And, you know, we couldn't tell what that number was. It was just, you know, we had to, you know, guess and check. That could be the basis of your third family, because at this point you had no idea what that limit was going to be. And this is just kind of, so at the end of the road, you have 3 different patent families, all with different start dates, all with different end dates. Because as we all know, you know, especially in life sciences where there is, you know, the FDA and different regulatory bodies, it might take a long time from when you first discovered your compound to you having, you know, FDA clearance to actually start marketing this thing. So by the time you start marketing, your first patent family might be come into expiration. So how do we stop people from, you know, how do we extend that exclusivity time? Is leveraging IP to keep extending that exclusivity time. So final thoughts, when do you file a patent application? It all depends, but you want to get the main things are you want to get in front of prior art, especially your own prior art, and you want to be in a spot where you can describe what you're trying to claim with enough detail so that someone in the field, quote unquote, gets it. For therapeutics, that might mean, you know, the structure of your compound or the sequence. Devices, you gotta say, okay, the elongated member connects to, you know, this pivot at a 120-degree angle. You need to be able to describe all those different aspects in a way that someone skilled in the art can put it together. And finally, the data can be added, you know, between year 0 and year 1, from that provisional filing date to your non-provisional conversion. The data could also be prophetic, not recommended, but sometimes it's what we have to do. And these are kind of the considerations. The number one thing is you want to make sure you at least file before you prior art yourself. So if there's anything to take away from today's talk, is just don't shoot yourself, don't become your own worst enemy. So if you have any more questions, I'll be able to stick around today to answer any questions. I'm holding office hours with ULP next week. Sign up, I think the sign up sheet should be on, I know it's on LinkedIn, but it should be on their website as well. Sign up for my office hours. Would love to talk to you. Shoot me an email, connect with me on LinkedIn. I love talking IP. So, thank you. And I hope to hear from all of you soon.